Today, many immigrants are panicking after a major Trump immigration policy announcement involving adjustment of status, green card applications, and USCIS discretionary decisions. People are asking, can I still apply for a marriage green card? Will pending I-485 applications now be denied? Do immigrants now have to leave the United States for consular processing? Is adjustment of status ending under the Trump administration? In this video, I'm going to explain what this new USCIS immigration policy actually says, who will be affected, who may not be affected, and what immigrants should realistically expect moving forward. First, it is very important not to panic. Based on the information currently available, this policy does not appear to completely eliminate adjustment of status inside the United States. At this time, adjustment of status under the Immigration and Nationality Act still exists as a legal pathway for eligible immigrants. However, this new Trump immigration policy may signal a much stricter approach by USCIS officers when reviewing and deciding green card cases inside the United States. One of the most important things to understand is the difference between filing a case and getting a final approval. From our current understanding, this policy appears to focus more on how USCIS officers evaluate adjustment of status applications during the final decision-making stage, rather than creating a new rule that completely prevents people from filing applications in the first place. In other words, many immigrants may still be legally allowed to file the Form I-485 adjustment of status applications if they qualify under existing immigration law. However, USCIS officers may now be encouraged to apply stricter discretionary review when deciding whether to approve those green card applications. This distinction is extremely important. Adjustment of status has always technically been a discretionary immigration benefit. Even if someone is legally eligible, USCIS officers still have the authority to evaluate the overall circumstances of the case before granting permanent residence. What appears to be changing now is the administration's attitude toward the discretion. The policy language strongly suggests that USCIS may place greater emphasis on consular processing abroad and apply more scrutiny to adjustment of status cases filed inside the United States. As a result, immigrants may potentially see more requests for evidence, more notices of intent to deny, more scrutiny regarding unlawful presence, immigration history, maintenance of status, unauthorized employment, or other discretionary factors. At this time, however, we do not believe this announcement means that all marriage green card applications or pending I-485 applications will automatically be denied. Strong immigration cases with clear eligibility, lawful entry, strong supporting evidence, and favorable facts may still continue to move forward successfully. It is also important to remember that immigration policies often evolve after the initial announcement. Additional USCIS guidance, litigation, federal court decisions, and future policy updates may significantly affect how this policy is ultimately implemented in real cases. So while immigrants should absolutely take this development seriously, it is equally important not to spread panic or misinformation online. If you currently have a pending adjustment of status case, are married to a U.S. citizen, or are considering filing a green card application, this is a very important time to consult with a qualified immigration attorney and prepare your case carefully. We will continue to monitor the USCIS immigration policy closely and provide future immigration updates as more information becomes available.